He sat in my courtroom with a smirk on his face, leaned back in his chair, and said loud enough for everyone to hear, "Judges, like you don't make decisions about people like me." If you have ever wondered what it looks like when the law faces someone who truly believes they are untouchable, stay right here, because this story will show you exactly what justice looks like when it finally arrives. Before I go any further, I want to be clear about something. This is a dramatized story inspired by real courtroom lessons. The names, characters, company, and locations in this story are entirely fictional. They're created to protect privacy and to share the deeper truth about accountability and the law. Any resemblance to real people or real events is entirely coincidental. Now, let me tell you about the case of Daniel Carter. I have served on the bench for many years. I have seen people walk into this courtroom afraid, angry, confused, and sometimes broken. I have also seen people walk in with their chins high and their eyes cold, completely convinced that the law is something that only applies to other people. In all my years, I have learned one thing above everything else. The law does not care how much money you have. It does not care how many people work for you. It does not care how powerful your name sounds in a boardroom. When you stand before the law, you stand as a person, nothing more, nothing less. That is the foundation of everything I believe about justice. I want to share this particular legal story with you today because it is one that has stayed with me. It tested my patience, challenged my understanding of responsibility, and ultimately reminded me why the work of a courtroom matters so deeply. Daniel Carter was the chief executive of a company called Harlow Industries. Harlow Industries operated a large distribution warehouse on the edge of Riverton City. Hundreds of workers spent their days there, lifting, loading, sorting, and shipping goods across the region. It was hard, physical work. The people who did it were not wealthy. Most of them were working to support families, pay rent, and put food on their tables. They depended on that job, and they trusted the company to keep them safe while they did it. That trust was broken. About 14 months before this case reached my courtroom, a man named Marcus Reed was working the night shift at the Harlow Industries warehouse. Marcus was 34 years old at the time. He had worked at Harlow for 6 years. By all accounts, he was a careful worker, well liked by his colleagues, and someone who followed the rules. That night, a section of heavy industrial shelving, the kind used to store large, stacked boxes, collapsed without warning. Marcus was directly beneath it when it fell. The injuries Marcus suffered were serious. His right arm was severely damaged, and he underwent multiple surgeries over the following months. He was unable to work for nearly a year. The medical bills piled up. His family struggled. And through all of that, the man who ran Harlow Industries, Daniel Carter, never once reached out to Marcus or his family to ask how he was doing. If you feel something stirring in you right now, a sense of unfairness, a question about how this could happen, I want you to follow this channel so you never miss a case like this one. Now, the civil lawsuit came first. Marcus Reed, through his attorney Jordan Blake, filed a legal claim arguing that Harlow Industries was responsible for his injuries because the company had failed to maintain safe working conditions. A civil case is about money and responsibility. It asks whether someone was harmed because another person or organization was careless or negligent. Marcus was not asking for revenge. He was asking to be made whole again, at least as much as the law could accomplish that. Harlow Industries had its own legal team, led by a very experienced attorney named Olivia Hayes. She was sharp, prepared, and skilled. She argued that the shelving collapse was an unfortunate accident, that industrial warehouses carry inherent risks, and that the company had followed all standard safety guidelines. Her position was calm and professional. She was doing her job, and she did it well. But Daniel Carter was not so composed. I first encountered him during a preliminary hearing, a short meeting before the main trial begins, used to organize the facts and set the rules for how the case will proceed. Daniel Carter walked into that hearing as though he were attending a meeting in his own office. He wore an expensive suit, carried himself with an easy confidence, and spent most of the hearing either whispering to his attorneys or glancing at his phone. When I reminded the room that phones were to be put away during proceedings, Carter looked up at me with an expression that I can only describe as faintly amused. He put the phone in his pocket, but the message in his eyes was clear. He was humoring me. It was not the first time I had seen that look. And I knew even then that this case was going to require careful attention. As the trial began and the proceedings moved forward, something interesting started to happen. The more Daniel Carter was present in that courtroom, the more his attitude became visible to everyone. He would sigh audibly when a witness described something that contradicted the company's version of events. He made quiet comments to Olivia Hayes that were loud enough to be noticed. During one particularly important moment in testimony, he actually laughed under his breath, and the people in that gallery heard it. I addressed him directly at that moment. I told him clearly that the courtroom required respect, not for me, but for the process. Not for himself, but for the man whose life had been changed by what happened at his company. Carter nodded, but the smirk remained. Think about what that must have felt like for Marcus Reed, who was sitting just a few feet away. If this story is making you think about what real accountability looks like, drop a comment below and tell me what you believe justice means. Marcus testified during the second day of proceedings. He sat in the witness chair and he spoke quietly. He described the night of the collapse in careful, measured words. He talked about waking up in the hospital. He talked about not being able to hold his young daughter properly for months because of the damage to his arm. He talked about the fear he felt every time he thought about going back to work at any warehouse and how that fear had changed him in ways that were difficult to explain. The courtroom went completely silent. I have been in many trials over many years. Silence in a courtroom is not unusual, but this silence was different. It was the kind that comes not from the absence of sound, but from a room full of people who are all feeling the same thing at the same time. Even Olivia Hayes, who was professional and composed throughout the trial, was still. Even the court reporter paused for just a moment. And I looked at Daniel Carter during that silence, and for the first time, I saw something shift in his face. I do not know what it was exactly, whether it was discomfort or something closer to guilt. But something moved behind those confident eyes. Then came the moment that changed everything. Jordan Blake, the attorney representing Marcus Reed, had been building something carefully over the course of the trial. He had been gathering internal documents from Harlow Industries, emails, maintenance reports, safety inspection logs. And on the third day of testimony, he introduced a piece of evidence that nobody on the other side of that courtroom had anticipated being made public. It was an internal email chain. The emails had been sent 11 months before the shelving collapsed. In those emails, the warehouse safety supervisor, a woman named Maria Torres, had written to senior management at Harlow Industries with a detailed warning. She had inspected the shelving units in that section of the warehouse and found that several of the base supports were cracked and weakened. She described them as a serious hazard. She estimated the cost of replacing them, and she requested immediate approval to take the damaged shelving out of service and order replacements. The reply she received came from Daniel Carter's own email address. He had written back 4 words, not in the budget. That was it. 4 words. After receiving a clear and documented safety warning about equipment that could injure workers, the CEO of Harlow Industries had decided that the cost of fixing the problem was not worth spending. And 11 months later, the shelving collapsed on Marcus Reed. The courtroom went completely silent again, but this time, the silence felt different. It felt heavier. It felt like the moment before something very important is understood. I watched the gallery. I watched the jury. I watched Daniel Carter. His attorney was already leaning toward him, speaking in a low and urgent voice. Carter had straightened in his chair. The easy confidence was gone. Something was replaced by a stillness that looked a great deal like a man who suddenly understood the situation he was in. This is the kind of moment that reminds us why the truth always matters. Share this video with someone who believes that accountability is the most important part of justice. Maria Torres was called to testify. She had left Harlow Industries 8 months before the trial began, and she came to that courtroom with no loyalty to Daniel Carter and no reason to hold anything back. She confirmed the email chain. She confirmed that she had followed up twice more after her initial warning, and that both follow-ups had been ignored. She confirmed that the shelving units were never repaired or replaced. And she told the court that after Marcus Reed was injured, she had gone to the Human Resources Department herself and been told, quietly, that the company was handling the matter legally and that she should not discuss the incident. Olivia Hayes cross-examined Maria Torres professionally and thoroughly. She raised questions about whether the emails alone constituted proof of direct wrongdoing rather than an administrative oversight. She argued that large companies deal with many maintenance issues simultaneously, and that a single email does not prove reckless disregard for safety. These were legitimate legal arguments. I gave them the consideration they deserved, but the weight of the evidence was clear. Here is how I understood the law as it applied to this case. When a company is responsible for workers who depend on them for safety, that company and its leadership carries a duty of care. A duty of care is a legal term, but it simply means this: you have a responsibility to take reasonable steps to prevent harm to others. That responsibility does not disappear because something is inconvenient, expensive, or not in the budget. When a safety hazard is clearly identified and clearly reported, and the person with authority to fix it chooses not to act, that choice becomes accountability. Daniel Carter had made a choice. That choice had consequences. And Marcus Reed had carried those consequences every single day for over a year. I also had to think carefully about the bigger picture. If I allowed a decision maker to say, in effect, that the cost of safety was not worth paying, what message does that send? It sends a message that the lives and health of working people are something that can be weighed against a budget and found wanting. The law does not support that message. The law says that human safety matters, and it is my job to say that clearly. After careful deliberation, I delivered the verdict. I found in favor of Marcus Reed. The court determined that Harlow Industries, under the leadership of Daniel Carter, had been negligent in a way that went beyond simple carelessness. The documented evidence showed that the danger was known, reported, and ignored for financial reasons. That level of disregard for worker safety crossed the line between an accident and a failure of responsibility. The damages awarded to Marcus Reed were substantial. They were designed to cover his medical costs, his lost income during recovery, and the long-term impact on his quality of life. The court also applied additional penalties, sometimes called punitive damages, specifically because the evidence showed that the harm was not accidental, but the result of a deliberate decision to ignore a known risk. Punitive damages exist not as punishment in the emotional sense, but as a signal, a clear statement that certain choices carry consequences that go beyond ordinary compensation. When I read the final decision aloud, the room was quiet in a way I will not forget. Marcus Reed kept his eyes forward. His attorney, Jordan Blake, placed a hand briefly on his shoulder. On the other side of the room, Daniel Carter sat very still. The man who had walked into that courtroom with a smirk and a confidence that borders on arrogance was now simply a man who had lost, not because the system was against him, but because his own choices had carried him here. Olivia Hayes, to her credit, was composed and professional. She thanked the court and advised her client quietly. Whatever she said to him, I do not know. But as Carter stood to leave, he did not look at Marcus Reed. He kept his eyes forward and walked out. I watched him go. If this verdict resonated with you, and you believe that no one, no matter how powerful, should be above the law, let this video remind someone who needs to hear that message today. I want to talk about something before I close this story, because this is not just about one man, one company, and one courtroom. This is about a question that every society has to answer over and over again. The question is this: who does the law protect? Some people believe, sometimes openly, sometimes quietly, that the law protects people with power and wealth more than it protects everyone else. I will not pretend that this concern has no basis. The justice system, like any human institution, is not perfect. There are cases where resources and connections make a difference. There are moments where the scales tip in ways that are not fair. I have seen that. I carry that awareness into every courtroom I enter. But I also believe something equally true. When the evidence is clear, when the truth is documented, when the facts are laid out in a place where they cannot be ignored, the law has the power to do what it was built to do. It has the power to look at a person in a $3,000 suit and say, You are not exempt. You had a responsibility. You chose not to fulfill it. And now you will be held accountable. That is what justice served looks like. It is not dramatic in the way that movies sometimes show it. It does not always come with applause or tears. Sometimes it comes quietly, like a verdict read in a still room, like a man who has to sit with the weight of what his choices cost someone else. Marcus Reed did not get his health back. He did not get those months of pain and worry erased. No verdict can do that. But he walked out of Riverton City Court that day knowing that what happened to him was not acceptable, was not his fault, and was not something that the law was willing to overlook simply because the person responsible had money and a title. That matters. That matters more than I can express in words. I will leave you with this thought. Every person who holds power, whether in a boardroom, a community, a government, or even a family, has responsibilities that come with that power. The law does not ask you to be perfect. It asks you to be responsible. It asks you to make reasonable choices that protect the people who depend on you. And when you receive a warning, when someone raises their hand and says this is dangerous, please listen. The law will hold you to what you did in that moment. Responsibility is not a burden. It is what separates leadership from entitlement. Thank you for being here for this story. If it moved you, if it made you think, if it reminded you of something important about fairness and compassion and the way the law can work when it works the way it should, then I hope you will carry that feeling with you. And I hope you will come back for more stories because there are many more lessons waiting in these courtroom walls. Until next time, this is your judge and court is adjourned.